now moving into the phases of trial. I can kind of give you a chronology where the parties are going to make their closing arguments. Mr. Kemp,
thank you. Good morning, ladies and gentlemen. First off, I'd like to thank you, Your Honor, and your staff for accommodating us last night. You may notice Jerry's a little tired today. That's because we were here till midnight last night. And, we appreciate you being here. We appreciate your time. Judge has been working with us on Saturdays, Sundays, just so you know, there's been a lot of effort made to try to get this thing moving, even though it doesn't appear like it's moved sometimes. In any event, this is the closing statement, and we're dividing it into two parts, liability and then damages. I'm going to be talking about the damages related to my two clients, Keon and the estate of the doctor.
you would just be louder.
Madam Court Recorder, I'm not on the screen either. Would you mind switching us over?
Okay, so liability, damages. I'm going to do the damages for two of the plaintiffs. Mr. Christiansen is going to do the damages for two of the plaintiffs. As I understand it, Mr. Barger is going to address liability, and Mr. Roberts is going to address damages from their side, and then Mr. Christiansen and I get one last chance to talk to you, and then you go through it. That's the way it's going to work. All right, let's start with liability. And I want to start with the year 1992. 1992. Okay, what happened in 1992? In 1992, this man was president. The first, not the second George Bush, the first George Bush was president. In 1992, Wayne's World came out. I don't know if you've seen it. In 1992, that movie came out. In 1992, this was the phone to have. It was a Motorola International 3200. That was the phone people coveted. Look at it now, it looks like an outdated product. 1992, this guy, Pee Wee Herman. This is when he was arrested for indecent exposure. He was caught in a movie theater inappropriately touching himself. But anyway, this all happened in 1992. And why do I start with 1992? Because that's where this case starts. Shane, can I have my first video? This is Mr. Cooch.
Was the E-Coach an existing product at that time?
No, it was new.
Okay, so you were designing a new bus, basically?
Right.
Okay, so 1992, you heard Mr. Hugestrat tell you this yesterday. They designed a new bus series called the E-Coach. That E-Coach, can I have the next one? Just to make sure we got the time, please.
Okay. What time period was the E-Coach designed?
From 92 was probably the earliest till 97.
And basically, the E-Coach became the J-Coach. They just did a facelift of the J-Coach. It wasn't a brand new bus series, it was a facelift. Let have the next one, please, Mr. Cooch.
The J-Coach is just a facelift of the E, really.
So, and Mr. Hugestrat told you that yesterday, too. So basically, what we have is a bus, in this case, that was designed in 1992, when this started the design, but it was made in 2007. It kept the same coach design. It was an outmoded, the fundamental issue in this case is whether they used an outmoded product line when it kept making the 2008 J4500 year after year after year. And why do we think it was outmoded? Because there were a number of safety improvements that we talked about during the case. And I showed you this slide during the opening statement. One of the jury instructions say that it's the date of sale. In this case, the sale is late 2008 time period. This is the time period that these inventions came about. 1993, they designed a safer, rounded alternative front, which we'll get into in a minute. 1995, that's when the S1 guard patent was filed. 1998, the Eaton proximity sensor patent was filed that we've heard about. This is 10 years before the bus, in this case, was made without the rear, which 14 years before they knew about, without the rear tire protectors, which 12 years earlier there had been a patent, and without the proximity sensors, which 10 years earlier there had been a patent. So clearly, this 1992 design could have been benefited by these safety alternatives. Now, Mr. Hugenstraat, when he testified yesterday, specifically told you that if you have an old product line, you have an obligation as a manufacturer to search for and evaluate new technology if you're going to keep that product line. Now, this is what he said.
Would you agree that a bus manufacturer who has a product line that starts in 1992 should search for and evaluate new technology during the time period the bus continues to be on the market?
Yes.
And that's the problem. They didn't do that. They did not do that in this case. Using the S1 guard as an example. The S1 guard, as of 2007, as of the present time, Mr. Hugenstraat said he didn't even know about the S1 guard until the year 2017. 25 years after the bus, in this case, was designed. He didn't know about it. This is his testimony.
So for the 8 years from 92 through 2000 and from 2000 till 2017, that's how I got to 25. For a quarter of a century, you didn't know about an S1 guard.
About an S1 guard.
So in 1992, when the bus was designed, we had these three safety inventions that come up. They admit they had an obligation to go out and get them, go out and look for them. They didn't do it. So that is really why we're here. That is the overriding philosophy of what happened in this case. Now let me talk about strict liability. The judge gave you a jury instruction on strict liability. This is a strict liability case. It is not a negligence case. So in a strict liability case where a company sells a product that's defectively designed or doesn't have an adequate warning, that company is liable without requiring proof of negligence. You heard the jury instruction. We do not have to prove that MCI did anything negligence. If it was a negligence case, like a regular car accident case, we'd have to prove that there was some sort of negligence. We don't have to prove that. This is a strict liability case. So the first inquiry in this case is whether or not the product was defectively designed. Next inquiry is whether that defect caused the injury in this case. And alternative liability theory is that there was a failure to warn related to the air blast danger. Now, the product can be defective and the cause of an accident even if the user of the product is not perfect. Okay? You got to remember, and some people have a hard time understanding this. This is the jury instruction 33. Any negligence by the driver, in this case, is foreseeable as a matter of law. In other words, they know that every driver is not a perfect driver. They can foresee that every driver is not a perfect driver. So you are not to consider any alleged negligence on the part of the bus driver. That's a hard thing for a lot of people to understand. I like to give them this example. If someone goes off the road and their airbag is defective and the airbag doesn't work, they can sue the airbag manufacturer for providing the defective airbag. The airbag manufacturer can't come in and say, oh, it's your fault, you ran off the road. And the reason for that is because the airbag is a safety device. The manufacturer is presumed to foresee that that car in which the airbag is installed can run off the road. In this case, the manufacturer of the bus is presumed to foresee that the bus driver is not a perfect driver. And so that means you are not to consider any alleged negligence on the part of the bus driver. And I guarantee you, when you go back to the jury room, someone is going to say, well, what about the alleged negligence on the part of the bus driver? This is the law, okay? You have taken an oath to apply the law. The judge just read you the instructions regarding applying the law. So if someone gets off base and starts, I call this the finger pointing instruction. The product manufacturer can't point the finger. This says no finger pointing. No finger pointing at the bus driver. Their negligence is not a defense in this case. Second, and in a strict liability case. Second, and similar. Can I have the next one, Jim? This is the very next jury instruction. Jury instruction 34. Any alleged negligence by Dr. Khiabani is not a defense to the plaintiff's products liability. So you are not to consider any alleged negligence on the part of Dr. Khiabani. Okay? And again, can't point the finger at Dr. Khiabani. It's like the airbag example I gave you. The manufacturer of the airbags, that's why they're making the airbags, so they can be used in the case of an accident. You cannot argue, it is not a defense to say that either the driver or someone else did something wrong. Those are probably the two most important jury instructions in this case. There's a third I want to talk about now. Can I have the next one, Jim? This is called the substantial factor instruction. When you get back there and you read the jury instruction, you will see the term legal cause. You see the first two out of the first three words, legal cause. So the court is trying to explain to you what a legal cause is. And that may be different than what you think a cause is, just using that terminology from your everyday life. A legal cause is a substantial factor, okay? Substantial factor. In other words, we don't have to prove that the defects in this case were a predominant factor, an overwhelming factor, the sole factor. We just have to prove that they're a substantial factor in causing the accident. And, you know, there's a lot of things that happen when you have an accident. You know, there's a lot of moving parts. We just have to prove that the defects in this case that we're talking about was a substantial factor. And these are the three, I think, the three most important jury instructions you can do. Now, let's turn to the facts of the accident. Okay, we have spent a lot of time in this case on the facts of the accident. Okay, and if you remember, I spent a lot of time during opening statement. I got the board out. I went through where the bus and the bike placement was according to each one of the fact witnesses. That is the key fact in this case, because right off the bat, in Mr. Terry's opening statement, do we have that, Shane? Right off the bat, in the opening statement, they made the claim that they were going to prove that the bike wasn't in the bike lane at the intersection, that the bike was in the far right turn lane. That's what they said at the opening statement. Apparently that went away, okay? Because yesterday, Dr. Coulthard changed it a little bit. Now he has the bike turning in front of the bus, okay? And we confronted him with the witness testimony, but in this case, we have 4 different witnesses. 4 different people. We went through the placements very carefully. Can I have, this is Bradley. Look where she has the bike and look where she has the bus. Okay? They're side by side at the intersection. Next one, Coach. Side by side approaching the intersection right at the crosswalk. And, you know, we had Dr. Coulthard on the stand yesterday. Mr. Pepperman was cross-examining him, saying, well, Dr. Coulthard, you're telling the jury that the bike went in front of the bus. And your testimony is inconsistent with all the fact witnesses. And by the way, the fact witness testimony, you heard the jury instruction, that is direct evidence. Eyewitness testimony is direct evidence. It's not circumstantial evidence, it's direct evidence. So we confronted Dr. Coulthard with Colch's testimony, with Bradley's testimony. This is Pierce's testimony. Mr. Pierce was in the far right lane, the far right seat. He saw the bike in the bike lane before the accident. The next one was the gardener. We don't have a placement for the gardener, but he testified he was in the bike lane too. So you have 4 different fact witnesses all saying the same thing. They're saying the bike was in the bike lane, the bus was in the bus lane at the time point, they were at the crosswalk, and the bus started passing. That is the key fact in the case. So we have 4 different witnesses telling you that this is what happens. And we have the defense, okay? Like I said before, they started off trying to put the bike in the far right turn lane. That didn't succeed, so now they're saying, oh, what really happened in this case is the doctor turned in front of the bus. 4 different people. And what did they say to you? They have Dr. Krause come in here and say, oh, witnesses, they don't remember, they're not reliable. And they have Dr. Coulthard say, oh, we have to disregard the witness testimony. It's not reliable. It's not 1 witness. It's not 2 witnesses. It's not 3 witnesses. It's 4 different witnesses, okay? This basically destroys their entire case. If you believe the fact witnesses, and this is what Dr. Coulthard said yesterday, if you believe the fact witnesses, you can't believe Dr. Coulthard. You know, we went through the scales of justice. We got 4 fact witnesses on the one side. We have and by the way, the plaintiff's experts are consistent with fact witnesses. But in any event, you know, which is probably more true? What the people that saw it with their own eyes are telling you, the people that are not being paid by the defendant to come in here in court and give some sort of opinion, the people that are not hired experts that have worked 34 times for Ford and over again for these other manufacturers. Who is more credible? These 4 people don't have any financial bias. They're just regular members of the community that happen to see a bus accident. And this is what they came in and told you. So if you believe these eyewitnesses, Dr. Carhart's wrong. Next, it was undisputed testimony that the bus driver, in this case, did not see the bike for the last 400 feet. Remember, we had Mr. Hubbard come in here, and he put for, okay, go ahead, please.
And for 450 feet after passing the cyclist at the city cutout, you never saw the cyclist again?
No, sir.
And so I'm understanding you correctly, sir. The bus that you were operating and driving for that 400 feet between the pink posted on the map and the 0 line, you did not at any point in time before this intersection between that 450 feet that we're discussing see the cyclist.
You mean from the cutout? No, sir, I did not.
Undisputed. There's been no argument about it. Okay? And think about it for a minute. The bus driver is approaching an intersection. Where should he be looking? Straight ahead, the oncoming traffic to his left. Their argument is that he should be steering to the right side of the front corner of the bus the entire time. That's their argument. And we know what that's going to show. That's going to show the blind spot. But in any event, this is undisputed testimony that for whatever reason, and we contended with the blind spot, for whatever reason, he didn't see the bike during that time. Now, another key piece of evidence is the Red Rock video. You saw Dr. Carhart didn't want to talk about the Red Rock video. Okay, in the Red Rock video, you see that shadow. You see the shadow that's Dr. Khiabani? And by the way, counsel, when they cross-examined our accident reconstruction expert, if you recall, they suggested to you that that's not really the shadow of Dr. Khiabani, that's the sun on the other side of the bus. Remember Mr. Barger doing that? When he did that, he knew all of his experts concluded that that's Dr. Khiabani. He knew that. He was just throwing something out there. But in any event, this picture alone proved, if you don't want to believe the 4 witnesses, look at this picture. Dr. Khiabani is behind the front of the bus. He's not turning in front of the bus. Is that my next one, Shane? Again, Red Rock number 3. There's 5 of them in the sequence, I believe. This is 3, first one was 2. The Red Rock number 1 was the one on the bus at the crosswalk, just showed the bus. Okay, again, you see the doctor behind the front of the bus. Not in front of the bus like Dr. Carhart said. Next. Another one. Doctor a little bit farther behind, but he is not in front of that bus. Next one. Again, the doctor is behind the bus, and as you can see, the bus is going faster than the doctor, so the shadow is moving farther along the back of the bus. Next one, please. Oh, go back, please. So we have 4 different witnesses, 4 different photos, and they all show that the bike did not turn in front of the bus. That's their theory of the case. You just heard it yesterday. You heard Dr. Carhart tell you that, according to physics, that he understood that the 4 eyewitnesses in these pictures have to be wrong. Okay? Think about that, ladies and gentlemen. 4 eyewitnesses, 4 pictures taken from the Red Rock video. That is wrong. The direct evidence is wrong, and the opinion of Dr. Carhart is right. Another important point that I think came out really for the first time yesterday, Dr. Khiabani lived to the west of the Red Rock Casino. So he was coming east down Charleston, he turned south on Pavilion Center to go home, and he was expected at home. You heard the testimony, we played it yesterday. to go home, he would turn right. He would go west. He wouldn't turn left. So Dr. Coulthard is suggesting to you that for some reason, Dr. Khiabani, in this case, turned left away from his house, turned into incoming traffic, okay? You know, turned into incoming traffic, and that was the cause of the accident. Makes no sense. Mr. Pepperman asked him on the stand, well, why do you think that occurred? Can you give us any reason why you are claiming that Dr. Khiabani turned left? He didn't have an answer. Okay. You've seen these pictures before. Okay, Shane. The point I want to make now is take a look. That's where the brake hood hit the bus. Do you see a mark from the helmet above that? Remember they brought Dr. Bodden in here to say, oh, gee, I think his head hit. And then he backed off and said, well, I'm sheer speculation that the head hit. There's no mark from the head hitting, no mark whatsoever. More importantly, a little lower than that, there's no mark for the tire hitting. Remember we went through this with our accident reconstruction expert, told you that if the bike had turned in, it would have damaged the bike. We spun the wheel, there's no damage on the bike. So it's pretty clear that what happened in this case, and this is what both of the experts, the accident reconstruction experts said, it's pretty clear that what happened in this case is that the hood of the brake hit the side of the bus. So that's another picture of the left-hand side of the bike to show that that was damaged. All right. Now let's talk about the right side blind spot. Let's start. This is the picture from Mr. Cohen. Remember, he was the 3D visualization expert. The bottom, you can barely see the tires on the bike. The top, the body, the entire body of the bike is blocked. Most of the doctor's body is blocked, and you can see the head. This is the shot that the 3D animation expert presented to you. And you remember Mr. Terry, he tried to move the bike over here, move the bike over there, move the bike over here to show that there was a better viewpoint, and he stopped when he saw how the right side blind spot was all over the place. But this is visual evidence of the right side blind spot. So in addition to that, we presented the testimony of a bus safety expert. And this wasn't any bus safety expert. This was the bus safety expert from the Amalgamated Transit Union. That is the biggest union. They represent 200,000 bus drivers. That is the biggest bus drivers union in the world. Mr. Sherlock is the safety specialist for the biggest bus drivers union in the world. This is his job. He investigates bus accidents. He told you he used to be a driver, he worked his way up in Seattle, and now he's in DC. He is the head investigator for the biggest bus driver union in the world. And this is what he said about the J4500's right side blind spot.
Do you have an opinion as to whether or not the J4500 bus in this case has a right side visibility problem?
Yes.
What is your opinion?
It's extremely bad and extremely unnecessary. It takes very little to lower the windshield base so that you can see down better. It takes very little to make the pillars thinner. The structural element in there that you can't change is only about that big. And the rest can be changed and intelligently designed so that you have unobstructed vision. Doors are available that are all glass, and you'll see that this has large obstructions. And all of that would help you, especially off in this peripheral area of your view. It's extremely important to have really unobstructed vision, and it's trivial to do it.
So here is the bus safety specialist from the biggest bus driver union in the world telling you that there's a right side blind spot. Okay, so we have the picture from Mr. Cohen. We have this testimony, and then we have their expert, Mr. Krause, or Dr. Krause, excuse me. So Dr. Krause, he said that they did right side visibility tests. That after the accident, they did right side visibility tests. Remember, there were no right side visibility tests done on the J series. When we played Mr. Hugestrad's testimony, he's the PMK. He said they didn't do any right side visibility tests on the J series. He also said he thought they did them on the E series, but when we asked him for them, he couldn't find them, so then he backed off and said, I don't even know if we did right side blind spot tests on the E series. So he's the PMK. You know, we read a PMK instruction That was jury instruction 16. And by PMK, I mean he was the 30B6 witness. When you look at instruction 16 in your book, you'll see it says 30B6 witness. He's a witness for 3 different areas, one of which is the right side blind spots. His testimony is binding. Binding. If you look at the last word of that instruction, it says binding. They can't flip-flop and say, oh, there's not a right side blind spot. He said there is. And first of all, Dr. Krauss, this is what he describes a 40-inch right side blind spot that's 5 feet deep.
Krauss, I just asked you, you'd agree with, I just asked you, you'd agree with,
Of course.
Dr. Krauss,
I
just asked you, wouldn't you agree with Mr. Sherlock's opinion that there was blind spot? Yes.
The blind spot I measured for the bike was 5 feet out and about 40 inches long.
Is that a yes?
So, yes, with that caveat.
This is their expert. This is not my expert. So their expert is telling you that this bus has a 40-inch, 5-foot deep right side blind spot. Moving to Mr. Hubestrak. We played his videotape deposition to you. He admitted. Please, Jake.
But let's go to a real J4500.
Let's go to real world,
Okay.
if that's all right. And yeah, it is a blind spot, although because the driver is quite a ways away from it, the angle is very narrow for the right-hand A-pillar. But an A-pillar in all vehicles creates somewhat of a blind spot.
You know, I don't think I'd call a 4-foot blind spot narrow, but in any event, he admitted that there's a blind spot. And the problem in this case is the blind spot gets worse the closer you get to the bicycle. We presented Mrs. Witherall's testimony. She was a real bus driver that drove the J4500 for approximately 14 years. You know, she wasn't some expert that they paid to come in here and drive buses up and down test tracks in Phoenix. She was a real bus driver. Here's what Mrs. Witherall told you about the right side blind spot. Well, excuse me, I think I have Hubbard first. Mr. Hubbard, the driver in this case, he told you there's a right side blind spot.
But there are blind spots on this bus.
Yes.
And now we have Ms. Witherall.
Okay. The J4500 has a right side blind spot?
Yes, sir.
And then she explained to us that it gets worse as you approach a bike on the right-hand side. Mrs. Witherall's testimony again?
So as of 2011, the J4500 still had what you considered to be a right side blind spot problem?
Yes, sir.
Now, as you approach an object on the right of you with the bus, does the blind spot problem get better or get worse in your experience?
It's as you're starting to pass it, and it gets starts to get worse.
Why is that?
Because you can, with your field of vision, you can see in front of you, but then as you're coming toward that right front of the bus, there's a field that's a blind spot.
And then even worse, she said that if you're approaching a bike, that is directly in where the blind spot would be. Can I have my next one, Shane?
So you're driving an MCI J4500 and you're approaching a bicyclist on the right-hand side. And Mr. Kemp asked you, is the blind spot worse as you approach 5 to 10 feet? In that scenario, as you're approaching the bicyclist on the right-hand side, at what point, if you sat stationary, would that blind spot kick in? While the bicyclist was still in front of you, or when he was parallel, or when he was behind you?
When he's probably, roughly, I'd say maybe 6 to 10 feet in that corner, you might not be able to see him. And then just as it gets, almost to the edge of the door there.
Exactly what happened in this case. You heard Mr. Hubbard's testimony that he first noticed the bicycle when he got to the edge of the door. But in any event, they didn't rebut this testimony. I'm going to talk about the jury instruction for consumer expectations. That's the user of the product. You look at their expectations. You don't look at Dr. Khiabani's expectations because he's not driving the bus. You look at the user of the product. In this case, it's the bus drivers. Okay? This testimony was not rebutted. They did not bring in any bus drivers to say that the coach does not have a blind spot. We have 3 different bus drivers that told you. We have Hubbard, we have Sherlock, again from the union, and then we have Mrs. Witherall. 3 different bus drivers with real-world experience. Decades. Hubbard's been driving for 20 years, she's got 14. Mr. Sherlock's got 25. So you have 50 years of experience of 3 different bus drivers that were driving this bus, and they all tell you that there's a blind spot. Their expert says there's a blind spot. Really not a dispute there's a blind spot. We have Sherlock, Kraus, Hugestrop, the PMK, Hubbard, Witherall, they all told you there's a blind spot. And there's been people killed because of these blind spots, in addition to Dr. Khiabani. Okay, Mr. Sherlock told you about a death case in New York. We played that yesterday. Let me play it one more time.
Have you investigated other fatality cases involving MCI buses where there were front and side visibility problems?
Yes.
And can you tell the jury about some of those cases?
One was an elderly woman who jaywalked, as I was talking about the problem in New York and New Jersey. This elderly woman walked in front, came between traffic waiting at a light, and the vehicles were very tall, 6 feet, and she wasn't. So she steps from behind these vehicles right in front of the bus, and now she's behind the pillar on the left, which is very similar to the pillar on the right. And the mirror and the high base of the window, she was unseen and crushed.
MCI bus, that's not a J4500, and it has the same type of blind spot problem. Next, he told you about a New Jersey case, another death case.
Where was that case at?
In New Jersey.
And what happened in that case?
A pedestrian was run over by the rear wheels when the driver couldn't see her behind this pillar and mirror structure. So you've got problems on both sides on this bus, and they're related in that big areas of the space you're driving through are blocked from view, and in both directions you can lose track of pedestrians who are tracking with those blind spots.
So we have 3 bus drivers. We have their PMK Hugestrop. We have their expert, Mr. Kraus, the one with the 40-inch, 5-foot deep blind spot. All those people are telling you there's a blind spot in this bus. Do you know the only person, or the only 2 people who testified that there's not a blind spot? The only 2 people who said, nah, there's no blind spot on this bus. It was the people who designed it. Those 2 gentlemen told you that there's no blind spot. Let's have Mr. Lamouth's testimony.
Okay, assuming that technique is not used, would you agree with me that there's a right side visibility obstruction?
No, I disagree with him.
Here's Mr. Cooch, another one of the designers. He was in charge of the design team. He was in charge of the design team for the J6. Here's what he said.
As I said, MCI's coaches do not have a problem with blind spots.
Okay, the 2 designers say there's no blind spot, but the PMK, the 30B6 witness, Mr. Hugestrop, that's binding on the company that there's a blind spot. But the important thing here is that I asked Mr. Cooch what you did to rectify the blind spot problem. You say there's no blind spot. Did you do anything to fix a potential blind spot problem? He told us that they didn't try to fix anything because he didn't think there was a problem.
Okay, so what did you do as head of the design engineering to eliminate, mitigate, reduce, whatever term you want to use, right side blind spots for the J4500?
I don't believe that we had any active initiatives at that time because we didn't have a problem.
Active initiatives, that's engineer speak for doing something about it, okay? They didn't do anything about it because he didn't think they had a problem whereas we see from all the other witnesses they did have a problem. Simple fixes here. They were very simple fixes to this blind spot problem. Mr. Sherlock told you about it. They could have lowered the high dash. They had the highest dash in the industry. Just lower the dash. How tough is that? They could have made the lower door. The middle door is not see-through. The lower door is see-through. Either they could have flip-flopped the doors, or as Mr. Sherlock said, they could have used all glass doors. Mr. Hugestrad said, oh, gee, that would make the bus noisy. One of the jurors asked, well, noisy? Have you tested this? No, no test. That's something that Mr. Hugestrad came up with. But in any event, this is the testimony again from Mr. Sherlock. If they had fixed the right side blind spot, if they'd done anything to fix it, would it have made a difference in this case?
Okay, and with regards to the good right side visibility that you've outlined and the bad right side visibility that this bus has, if you had cured those problems, would that have made a difference in your opinion?
It seems extremely likely that Mr. Hubbard would have seen the bicycle coming his way earlier if the bicycle wasn't something like 90% obscured.
He said it again. Can I have it again, Shane? Okay, and with regards to the good right side visibility that you outlined. We have the same book price. Okay.
And it is your belief that if he had had better visual lines, he would have turned sooner?
Precisely.
And that would have avoided the collision?
It could have either mitigated or avoided.
Okay, they could have designed the bus to eliminate the problem. Could have been a physical fix. Okay, the other solution here was the proximity sensor. Okay, so let's talk about, and this is the second defect on the verdict form. At some point we'll talk about the verdict form. This is in general how a proximity sensor works. This is the illustration you've seen a couple times. The rays, it's either LiDAR or radar. There's two different types. They shoot out and then they bounce back and they have some sort of alert system. Okay, the rays actually go out farther than this. If you remember, Mr. Sherlock testified that they went out 300, 350 feet. But this was one solution that they could have done. Remember, the bus was designed in '92. This came out in 1998. Okay, so they would have had to be, and then the bus was made in this case in 2007. So they had 9 full years to, remember they said they were supposed to investigate new developments, implement new developments, 9 full years to get this proximity sensor system on a bus. Mr. Sherlock explained other buses, their competitors had proximity sensors, specifically the Eaton system, in 2007, the exact same year this bus. Remember, they say they're the leader in the industry. They sell more of these motor coaches. I keep calling them a bus, and they like to be called a motor coach. Okay, but they sell more motor coaches in North America than anybody else. They claim they're the leader in the industry. Okay, so we ask them, did other buses and motor coaches have proximity sensors? This is a motor coach. Please.
Did other buses have proximity sensors?
Yeah, certainly the BCI did.
When did that come out?
07.
2007?
2007, correct.
Okay.
And we're going to get to the Motor Coach News edition that came out on October 15, 2007, where this BCI bus is on the front page, and there's a description about the proximity sensor system in the article. That's why we were asking questions to Mr. Hugestrad yesterday to establish that he subscribed to that publication. In any event, this system was out there. They knew about it because they had Bus and Motor Coach News. Mr. Hugestrad, again, he is the 30B6 witness. So go back and look at the jury instruction. One of the areas he was designated as the 30B6 witness. There's 3 areas: right side blind spots, proximity sensors, the second one. But one of the areas was proximity sensors. So what did he say when we asked him in his 30B6 deposition if he knew that proximity sensors were available?
I mean, if you just wanted a warning system, you could buy the system from and put it on the bus, right? That wouldn't have brake compatibility.
Kemp, but you could give the warning.
Warning of what?
Side objects to the side of you.
You can buy systems that give little warnings if that's, I guess.
He knew the systems were out there. He knew about this, okay? At the time the bus was made, they didn't put it on the bus. So the evidence is established. The J4500 had a right side blind spot. They knew about it. There were front and side proximity sensors, or they could have even used cameras. Okay, that was another option available. Competitor buses, this is the BCI Falcon 45, which we'll get into a little bit, used proximity sensors, and they didn't do anything. They didn't design the bus to eliminate the right side blind spot problem. They didn't get a proximity sensor. They didn't get a camera system. They didn't do anything. So, issue. Would a proximity sensor have made a difference in this case? Here's Mr. Sherlock's testimony about how a proximity sensor would work.
So if that's the kind of sensor that is on the bus, the side proximity sensor, if that's what is on the bus, that sensor would provide no information about Dr. Khiabani, would it?
I don't think that's true. It depends on the sensor range of operation. If it's one of these that has 180 degrees, it's going to alert you to the presence of the doctor. If it's the 360 designs, it's going to alert you to the presence of the doctor. If it's a wide sensor on the front, which is integrated into these systems, then it would tell you about the doctor.
Okay, this wasn't rebutted. They did not call anybody with regards to proximity sensors to tell you that Mr. Sherlock was wrong. They didn't call one single witness that said, oh, a proximity sensor wouldn't have worked in this case for this, that, or the other reason. You know, we heard about the S1 guard till we're blue in our faces, but they didn't call one single witness to say that proximity sensors wouldn't work, okay? This is unrebutted. Instead, we had a series of witnesses who all told you that they thought the bus should have had a proximity sensor. And again, when you get the jury form, it's going to say consumer expectations. That's going to be the language. I'm going to show it to you. But the consumer in this case is the bus driver. That is the user of the product. The product is the bus. So under the consumer expectations test, it's what does the consumer expect with regards to safety. All right? So I'm going to show you what the bus drivers, the real world bus drivers, said about whether a proximity sensor should have been on his bus. First, let's go back to Mrs. Witherall.
Think proximity sensors are a good idea?
In my personal opinion, yeah.
Why is that?
Just because the right side of the bus is, you know, like I said, you've got more blind spots on your right side than the left side of the bus. Okay. And anything's better as long as, you know, anything that increases the safety is better for everybody.
How can you disagree with that? If it increases the safety, it's better for everybody. Mrs. Witherall, again, she expressed her opinion a little more forcefully.
She earned an opinion as a bus driver for the last 20 years that all buses should have proximity sensors.
On the right side, maybe, yeah.
On the right side.
Mm-hmm.
Mr. Hubbard, the driver in this case, told you that all buses should have proximity sensors.
Mr. Hubbard, in your experience, would a proximity sensor or camera on the bus be a good idea?
Yes.
They didn't call one single expert, with the exception of Mr. Krause, or Dr. Krause, who I'm going to get into in a minute. They didn't call one single expert that told you that proximity sensors are a bad idea. And do you know why? It's because every one of their experts has proximity sensors in their personal cars. Remember Mr. Rakoba? He was their first one. He had the two Kias from Korea that he gave to the wife and the daughter that had proximity sensors. We had Mr. Granite. He had the Ford Explorer that has a proximity sensor. But my all-time favorite in this trial came from Dr. Krause. This is what he said about the proximity sensor in his car and why he uses it and how it works. Dr. Krause, their expert.
And she can't see your kids' bikes. So it's important for your wife's car she be able to see bikes.
Well, when you're pulling up, so just like you quoted from my book, that trucks and cars necessarily will have some sort of blind spot owing to either the length of the hood or just the instrument cluster if you've got a completely flat front. There is definitely a blind spot, and like I said earlier, the lower the object, the greater the blind spot. So if I'm standing in front of her car, she can see me just fine, probably doesn't need the proximity sensor. But for the bucket that we have that sits in front of her car in the garage and for my kids' bikes, she can't see those. So the beeping is actually very helpful for that.
This is their expert. A proximity sensor that beeps is very helpful to his wife, very helpful to his wife to see bikes in their garage so they don't run over them. But then he turns around and says that, oh, we don't need a proximity sensor for buses because that would be too much information for the bus driver. Do you remember him saying that? We can't have the proximity sensor with the red light or the beep or whatever. That would be too much information. It would be distracting. Well, that's not what the bus driver said. That's not what Mr. Hubbard said. That's not what Mrs. Witherall said. That's not what Mr. Sherlock from the union said. They all wanted proximity sensors. So it's helpful for their families and for their wives, but it's not helpful for MCI to put up this particular bus. So let's talk about what a proximity sensor would have done. And let's start with the front proximity sensor. First, we had Mr. Sherlock's testimony. Again, he's the union bus safety specialist. This is what he said. Would a proximity sensor have made a difference in this case?
Let's start with the proximity sensor. Would a proximity sensor have made a difference in this case?
Especially if it was used as a blind spot sensor. The guide does speak specifically to that.
And by make a difference, I'm referring to would have been allowed the driver to move the bus over so that it would have been over another 4 inches and not run over Dr. Khiabani.
There's an extreme likelihood the driver, for whatever reason, whether he's looking in his mirrors or whatever he's doing, he seems to be unaware of where that bicycle is for a stretch of time prior to its moving over. Had this system alerted him, hey, come on, check, you've got a problem going on, and told him where to look, as some of these do, there's a fair certainty this would not have occurred.
All right. And Mr. Hubbard testified in this trial that if he'd been alerted earlier, he would have taken evasive action earlier. This is his testimony. Remember, he did take evasive action, just wasn't successful because it started too late. He said if he'd been alerted earlier, he would have taken evasive action earlier.
If you would have been alerted to the bicyclist earlier than your peripheral vision, would you have taken evasive action earlier?
Yes.
And how much earlier could a proximity sensor with the 350-foot front range, how much earlier of a bus traveling 25 miles per hour would it have alerted Mr. Hubbard? We asked this question of Dr. Krause, and here's what he said.
How many seconds does that bus travel in 350 feet? Is that easier?
So are you talking about specifically closing in on the bike?
Yes, sir, please.
So at about 20 feet per second, it's going to be, is that about 8, no, sorry. My math is very bad, about 17 seconds?
17 seconds, not 1.7 seconds. 17 seconds is when the proximity sensor would have started the alert at 350 feet. We go down to 300, 250, 200, the time gets less, but that is the outer range for the front proximity sensor. 17 seconds. Now, Mr. Sherlock said the bus driver in this case, because he was already turning, didn't need 17 seconds. He needed 0.1 to 0.12 seconds because he was already turning.
Well, it's less than 1.25 seconds, right?
Way less.
Probably in the neighborhood of 0.10 to 0.12 seconds.
Oh, sure, yeah.
And with regards to a left proximity sensor, would that give warning? It's Friday, ladies and gentlemen. Would that give 0.10, 0.12 seconds warning, additional warning to the bus driver?
It seems likely.
17 full seconds of warning would not have made a difference in this case? They don't tell you that it wouldn't. Okay, they did not present any testimony that if a proximity sensor had gone off and given 17 seconds additional warning, that wouldn't have presented the accident. The only thing they say is Dr. Krause says, can't have a proximity sensor because it would distract the driver. That is their testimony in this case. That is their justification for not having a proximity sensor, or that it would not be a cause to save Dr. Khiabani. That, in his opinion, it would distract the driver. All right, let's move over to the S1 guard. Two different witnesses testified that the S1 guard is a good safety feature and it should be used on all buses. Remember the testimony, it's used on 50,000 buses now. Disney World has it, Santa Monica Big Blue has it, a lot of transit buses have it. This is Mr. Barron's testimony. He is the inventor of the S1 guard. He looks like an inventor. But he testified, and he studied the industry. He went through it with you, all the statistics and everything. This is his business, the S1 guard business. This is what he testified.
Do you believe that the S1 guard should be standard equipment on all buses?
In the U.S.?
Yes.
The U.S., yes.
Based on your experience in the industry, do you believe that the safety benefits of an S1 guard outweigh the cost to equip the bus?
Absolutely.
He also told you that right now, as we speak, there's approximately 500 of these big blue buses, and they have MCI J4500s, 500 of these big blue buses running around Santa Monica with these S1 guards, and they're going back and forth from the airport to hotels, just like was done in this case, okay? They picked up some of these people, tourists, at the airport, and they took them to the Red Rock Casino. That was the use of the bus in this case. This is what he says about the Santa Monica Big Blue.
In fact, I think you mentioned that you have sold S1 guards to motor coach companies, right?
Yes.
And you mentioned specifically motor coach companies that shuttle people from the airport.
Santa Monica Big Blue is a good one here in Los Angeles. It's running about 500 buses. They have MCIs.
And the reason this is important is because I don't know how many times they stood up and said, oh, we're a motor coach, we're not a transit bus. Santa Monica Big Blue is a motor coach. They're running 500 motor coaches, including the MCI motor coaches, back and forth from the airport to the hotels in Los Angeles. It's being used. And I don't have it tagged, but if you remember in his deposition, they asked, do you know of any problems? Even one reported problem, Mr. Barron? And he would know. He's the one who's making the S1 guard. Doesn't know of one single reported problem. All right, and then early on in the case, we had testimony from a man named Ellis. He was an engineer at New Flyer. New Flyer was another bus manufacturer that makes transit coaches, but he was actually involved with a company that was putting the S1 guard on the transit buses at the factory. They did it at the factory. If you remember, we showed you the S1 guard literature. The very first name was New Flyer as a user of the S1 guard. So this person has real world experience in putting on S1 guards. Again, he's an engineer from a different bus manufacturer, New Flyer. And we asked him, do you think this should be used for all buses? You know, because, and the reason we got this testimony is, you know, Mr. Barron, he's trying to sell these S1 guards, so we got to take his testimony with a grain of salt. This person is not trying to sell S1 guards. This is an engineer for a rival bus.
And would that be a good safety feature for buses in general?
Again, it's my personal opinion, would say yes. But if it was just me, that sure, any time you can improve safety, you would want to consider that for sure.
Anytime you want to improve safety. Sounds like what Mrs. Witherall said. All right. They came in and said, geez, we can't use S1 guards because there hasn't been real-world testing, all right? Well, there hasn't been real-world testing, but right now they're on 50,000 buses. 50,000 buses, and the federal government pays 80% of the cost. Okay, remember we got into that with Mr. Hugenstreit? So our government pays 80% of the cost of these. They're on 50,000 buses, and they say there hasn't been real-world testing. Well, there was real-world testing. There was an accident that happened in 2003 in Los Angeles. Okay, we tracked down the person that was in the accident. That bus was going 25 miles an hour, just like the bus in this case was going 25 miles an hour. This gentleman did not have a helmet on. Didn't have a helmet on, okay? This is his testimonial as to what the S1 guard did in a real accident that happened in 2003 in Los Angeles.
After the accident, did you ever believe that you could have been killed if it hadn't been for the S1 guards?
Yes, I thought I would have gotten killed.
Do you, if we look at Exhibit 2, on page P01317, at the top it says, quote, the S1 guard is designed to deflect a person out of the path of the wheels. Did the S1 guard work to deflect you out of the pathway of the wheels in your accident?
Yes, I think so.
Do you think based on your experience, do you think the S1 guard is an effective safety device?
Yes, it worked for me.
This is not a test dummy. This is a real person who was involved in a real accident, riding a bike where the bike tipped over, he went under the bus, and the S1 guard saved him. Only difference was he didn't have a helmet on. Dr. Khiabani had that. So we get into the big debate here between the coroner and Dr. Stolniker on the one side and Dr. Carhart on the other side as to whether or not there was an inch going over, the sidewall was going over Dr. Khiabani's head, or was it more of the tire, okay? And the reason for that big debate is they want to argue that, hey, even if there had been an S1 guard on the bus, it would have made a difference in this particular case. That's their argument. So that's why they came up with the pinch theory, all right? And you remember what Dr. Carhart told you? This is not the first S1 guard case he's worked on. Remember, he said that he has been involved in previous cases with regards to S1 guards. So it's not the first time he's taken the witness stand. But let's start with Dr. Stolniker. Just briefly on his qualifications, Dr. Stolniker is the person that wrote the article from 1973. 1973, he wrote the seminal, the leading work on this, because as we told you, and you know, they seem to, every time his name comes up, they go, oh, geez, some of these monkeys had to be extinguished after the testing. You know, like that makes the results of the test wrong. And that you should hate Dr. Stolniker because they were using live animals back in the 70s. Okay? So he was using live animals, he was using cadaver skulls, he was doing some, and what were they doing? They were trying to figure out if a skull is crushed, where does it break? You know, is there a circular skull fracture like we have in this case, or is there something else? So this is what Dr. Stolniker said. And by the way, before I forget, he's also a helmet expert. He testifies in a lot of helmet cases as well. And you would expect that because with this kind of expertise, you know, the head and the helmet being crushed, that would be the kind of case you'd see him in. All right.
Now, based on your analysis, did you determine the amount of tire that came into contact with Dr. Khiabani's helmet?
No. It was, I mean, the tire width, there was no way to say that the whole tire part, there was some approximately, I think it was about 6 or 7 inches of the tire was over the helmet, but I don't know whether it was inboard a little bit or outboard a little bit.
Okay, and he also told you specifically that an S1 guard, if had been on this bus, would have saved the doctor.
In your opinion and based on your analysis, if the S1 guard had been installed per the manufacturer's instructions, about an inch in from the tire tread, would the S1 guard have contacted Dr. Khiabani's head?
Yes, it would have.
And would it have prevented Dr. Khiabani's head from being run over by the rear wheels of the tire?
Yes, it would have knocked his head out of the way.
And is that opinion to a reasonable degree of scientific certainty?
Yes, it is.
Shane, let's skip the next Stonecker clip and go straight to the skull fracture. This is the circular skull fracture, and that's been highlighted. I told you during opening statement that it was highlighted. You know, I can't believe what Dr. Carter, oh, gee, someone highlighted that. Of course, I told you it was highlighted. In any event, that is what's called a circular skull fracture. Dr. Carr didn't know much about it because he's not a doctor. Okay, he's not a medical doctor like the coroner was in this case. But in any event, this is a circular skull fracture. So their theory, remember he brought up the example of the egg? He brought up, okay, ladies and gentlemen, if you drop an egg, this is what happens. You break it a little bit, and then it breaks more easily. Well, their theory is if you pinch the side of the head, like the side of the egg, if you pinch the side of the head, the bottom of the egg is going to break. That's their theory. Okay, that's the pinch theory. All right? That if you pinch the side of an egg, the bottom of the egg is going to break. If you pinch the top of the head, the side of the head is going to show this circular skull fracture. And that's why experience with regards to skull fractures, like Dr. Stonecker has, is important. Let's get the next one. This is the clip where Dr. Stonecker said that the pinch theory is impossible. This is what he told you yesterday. We played the clip yesterday when Mr. Pepperman was cross-examining. Let me see my slide here. This is what we got, okay? And I showed you this during opening. You know, this case really hasn't changed that much during opening. Since opening, we have Stonecker on the one side. His opinion is supported by the coroner in this case. She's not getting paid by either party. She's an employee of Clark County. She's an independent, neutral witness that came down here. So we have Dr. Stonecker and the coroner against Dr. Carhart. All right, the coroner specifically said that the skull was crushed and not pinched. This is what she said.
The skull was crushed. If this helmet's 1.5 inches thick, and the injuries you saw were where the helmet sits on the forehead, it was more than 1 inch that crushed the skull, correct?
Yes.
It didn't pinch his skull, it crushed it. Right?
Yes.
That's the coroner's testimony. They want you to disregard the testimony of the coroner in this case and buy into this pinch theory. All right? Let's have Dr. Gavin again saying that to a reasonable degree of medical probability that the skull was crushed.
Dr. Gavin, the injuries you see both in Exhibit 247, the filmed x-ray taken at your office, as well as Exhibit 253, the photograph of the external examination you performed on Dr. Khiabani, are those injuries consistent with a crushing mechanism?
Yes.
Are they inconsistent with the sidewall of a tire striking the side of somebody's head?
This doesn't look like that's what happened. This looks like something went right over that portion of his head and pressed his head, essentially squished it, crushed it.
Crushed it, and the head is inside the helmet. So if we look at the helmet, crushed it down into the asphalt.
Yes.
And it was the tire that ran over his head and caused the crushing, in your opinion?
In my opinion.
To a reasonable degree of medical probability?
Yes.
Now they're going to tell you, well, you should disregard all this testimony because the coroner didn't come up with all these fancy 3D graphics that their expert had yesterday. But the coroner, in this case, was the one that actually touched the body. The coroner, if you remember, told you that she put her hands on the body and she analyzed the skull with her own hands. The coroner is the one that went out to the scene immediately and investigated the accident. You saw the pictures that they were taken within 2 hours of the accident. The bus is still on the road by the Red Rock. The coroner is out there investigating. So, and the coroner is a medical doctor. Dr. Carnaker, you know, starting with Carhart, turned into a Carnaker. Dr. Carhart, and I'm tired like Jerry, we were both here left. I'm sorry, Jerry. Okay. I didn't mean to call you out, okay? But anyway, the coroner is a medical doctor, all right? She's telling you, to a reasonable degree, a medical probability. Dr. Carhart is not a medical doctor. All right, let's shift away from the S1 evidence to the aerodynamic issue. And I brought that up last because it's last on the verdict form. And number two, the first three issues really don't have anything to do with aerodynamics, so I didn't want this to get bogged down by the aerodynamics. Aerodynamic issue. There should be no dispute that the bike wobbled in this case. That was the key fact I was trying to convey during the opening statement, that Mrs. Bradley was going to say that the bike wobbled. She testified to it numerous times. Let me just play a couple clips.
So when you saw him wobble, did you see him wobble to the right and then the left, or what did you see?
What caught my attention was the last, or I don't know if it was the last or first movement, but he wobbled to the left into the bus.
Okay, and when he wobbled, was it at the time the bus was passing him or ahead of him?
They were even.
So they were even at the time that he wobbled, that you saw him wobble?
Yes.
Have the next one, please.
Summerlin, according to the report by the media.
Okay. This was Mrs. Bradley's testimony, not refuted. They didn't call one single witness and said there was not a wobble. Instead, they jumped completely over that part of the accident. They argued, like Dr. Carr did, is that he thinks that the bike turned in front of the bus. Couldn't have happened if you believe the eyewitnesses, couldn't happen if you believe the Red Rock video. But they don't like the wobble, okay? They don't like the fact there was a wobble. They don't like the position of the bus and the bike when it wobbled. And the reason is they have no explanation for the wobble. Okay, now starting towards explanations, one of the jurors had a good question of Mr. Caldwell. They asked, well, geez, you know, could the wind, the Summerlin, have anything to do with the wobble that day? And I just want to get this out of the way quick. It was a good question, but it was an easy one to eliminate.
Yes, and so the second question is consistent with the first. Was it windy the day of accident?
And again,
I think we had the first part of Caldwell that started playing. In Summerlin, according to the report by the meteorologist. Do you have that? I'm sorry, ladies and gentlemen, we were up late last night. Some of us didn't get any sleep.
Summerlin, according to the report by the meteorologist that researched the weather that's much closer to the accident site, just before the event, it was blowing at 2 miles an hour out of the west and gusting to 6.
Yeah. And the next one, please.
Yes, and so the second question is consistent with the first. Was it windy the day of accident?
And again, I would consider those reported wind velocities not significant for a bicyclist in terms of it being windy. Obviously, there's some gustiness that's probably about a factor of 2 on the constant wind velocity, but I don't consider those to be very windy conditions.
All right, and they haven't argued that wind was a cause. They haven't argued that at all. I just want to point that out. Okay, these are the causes that we've looked at in the case. Have the next one, please. This is the same slide I showed you at the very beginning of the case. All right, the possible wobble causes. We have the air blast. That's our position. They dispute it. And here we're looking at what caused the wobble. The bike problem. We asked Mr. Rakova. No evidence. We asked him about road impediment, no evidence. We asked about physical impairment of the doctor, Remember the coroner's office testified, or the coroner testified that they did the electrolyte study on the doctor and it was normal, so he wasn't dehydrated. So no evidence of that. No evidence to support any of these, okay? No evidence. Not a little bit of evidence, no evidence. And Mr. Rakuba expressly said that. So we've given you the air blast evidence, and I'm going to go through that in a minute. But we had Rakuba on the stand, and first of all, he told you that he doesn't even have an opinion on what caused the bike to wobble.
Now let's see if we can establish a point. You do not have an opinion as we sit here today as to what caused the wobble, correct?
Correct, I do not.
And you know they're going to stand up here, and even though the jury instruction says you can't consider contributory negligence on the part of the doctor, they're going to stand up here and they're going to try to dance around it and get close to it and imply to you that the doctor did something wrong. I guarantee you that's what they're going to do. So I asked him if there is any evidence whatsoever, any evidence, this is their accident reconstruction expert, any evidence with regards to human error being the cause for the wobble. Isn't it true? No evidence whatsoever of human error with regards to being the cause of the wobble.
True.
No evidence.
True.
No evidence, okay? Now let's look at the evidence about bikes and the aerodynamic issue. Let's take a look at the evidence that we have about the air that actually comes off a J4500 bus and what it does. We have 4 different kinds of evidence. We have the testimony of Witherall, again, she's the bus driver, okay? We have the testimony of Sherlock, the union from the ATU, the safety specialist. We have the scientific paper by Dr. Cato, which both experts agreed this was the science on the case. And then we have an aerodynamic engineer. So here is what Mrs. Witherall told you.
And back to the air blast. You have personally stood next to a J4500 at about 25 miles per hour, a foot away, correct?
Yes, sir.
Tell the jury what you felt.
Just, it's, you feel the air as it's coming by you, and it's a little unsteady feeling that you feel.
While you're standing there, it makes you feel unsteady?
But I wasn't stumbling, it just gave you the feeling of being unsteady.
Let's stick with 25 miles per hour.
Okay. It's just, you can feel emotion.
Motion from the air?
Yes, sir.
Okay. All right. Is the same true at 2 feet?
Yes, sir. Not as bad, probably.
What better evidence could you have than a real bus driver who's got 14 years experience driving the J4500 that is in the bus yards where the J4500 is going by her? What better evidence could you have? And they didn't call any bus drivers to say, oh, when the J4500 goes by us, we don't feel anything. There's no, not one. They didn't call anybody. Instead, they called Dr. Carhart and Dr. Granite, who testified that, oh, we ran buses up and down a track in Arizona when it was windy. You know, it was windy that day, 8, 9, 10, 11, 12 miles an hour wind, and we couldn't measure a 200-pound weight being moved. They didn't even measure. What's this case about? It's about how much wind displacement or air blast comes off a J4500. They didn't even measure that. They didn't measure the wind coming off the bus. You know, he told you that. We had the anemometer with Mr. Granite, which is what the weather services use to measure wind. They didn't use that. They ran these buses up and down. They didn't want to know what the wind was. They had the artificial test, which I'll talk about, probably not in this segment, but probably in rebuttal. In any event, that was Mrs. Witherall's testimony. The next bus driver that testified was Mr. Sherlock. And why am I focusing on bus drivers? Again, when you look at the consumer expectations instruction, you'll see it's the user of the product, the bus driver. That's who we analyze. We don't look at the bystander like Dr. Khiabani. We don't look at other people. We look at the user of the product, the bus drivers. This is what Mr. Sherlock said.
And as it does that, it has momentum. And when it tries to go around the corners, that momentum carries it wide. So the air on the side doesn't go around like in a well-designed vehicle. It shoots out to the sides, and that creates a pressure wave where that jet of air is coming off, and that would push a bicyclist away. And this is well studied. There's a Cato paper that you'll probably see that goes into this in detail. So it pushes the rider away, and then it sucks them in, because right behind that pressure wave is an area that's a partial vacuum. And that's what led to these problems I was talking about with air quality, all these other things.
Two different bus drivers both say that the J4500 creates an air blast. Going to the science, let's see Dr. Cato's paper. This is the 1981 paper, relied upon by the experts from both sides. And what are they studying? They're studying the aerodynamic effects of a bicycle, to a bicycle caused by a passing vehicle. They want to see the reasons why a bicycle wobbles, just like the bike in this case wobbled, according to Mrs. Bradley. They want to look at the aerodynamic effects to the bicycle by a passing vehicle. Next one, please. I'll go over this quick. I know you're sick of Cato. Same procedure that we had from Dr. Greenthal. Push force, pull force. And the closer you get, the more force. Next one, please. So we applied this to the Red Rock video. So the doctor, when he's at this point, it's probably after the push force has started, but it starts, the push force occurs for the first time as the passing begins. And they have disputed that. They have not disputed this is the science. Remember we had Mr. Brand on the stand, he said this was a good article. Not only was it a good article, he downloaded it himself. Didn't dispute the science. Next one, please. Now, when they come closest together, it pulls the bicycle towards the vehicle. This is a 1981 paper. It's not something that one of the experts ginned up. It's a 1981 paper. Next, please. And then the closer you get, and this is the red rock before where you can see that the doctor is close, the closer you get, the more pulling you have. So we have Cato's paper, and now we have Dr. Breedenthal. Okay, Dr. Breedenthal. They could have called an aerodynamics expert. You know, obviously they spent a lot of money on other experts. They could have called an aerodynamics expert. They didn't call an aerodynamics expert. Every single expert they called did not have a bachelor's degree, a master's degree, or a doctorate degree in aerodynamics. Okay? Dr. Breedenthal has all three. In addition, this is his, 40 years ago, he did his paper with regards to blunt objects causing air displacement. 40 years ago. He studied aerodynamic issues with regards to other bus cases. These are the things he told you, and I don't want to get into radii, although I can pronounce it right today. But he told you that there's a 10-pound push force, and then there's a pull force that will last 0.25 seconds. But this is the important thing. Okay, I went over this with Mr. Hugestrad a little bit. If they had done a safer design like the Mercedes 500, the Mercedes 500, which has the 0.33 drag coefficient, if they had done a safer design, the push would have gone down from 10 to 3, and the pull would have been gone. Would have been gone, no pull. So instead of 10 pounds of push and 20 pounds of pull, you would have had 3 pounds of push and no pull back. That's what they could have done, they didn't do it. Next, North, please. Did they know how to do it? Of course they knew how to do it. They hired, I don't want to get into Dr. Cooper, but he was the one that did the paper in 1985 about this subject. So they went and they hired Dr. Cooper to do these wind tunnel tests. And look at the date. It's August 1993. It's about 2 years after they started designing the E-Series. After they started designing the E-Series. So they have suggested to you through some testimony which I thought was pretty hilarious. We'll get to in a minute. But they have suggested to you that somehow or other they used this report that came 2 years after the time that they designed the bus. Next, please. That's the standard MG3, that's the proposal 1. I don't want to get into a lot of detail here. The point I want to make, though, is they had a safer alternative front that they could have used in 1993. The bus in this case was made in 2007, so they could have started using this in 94, 95, 96, all the way up through 2007. They didn't do it. Next, please. These are just the comparisons. The new MCI refers to the safer design. That's the lower drag coefficient. Remember, the Mercedes Setra has the 0.33. They could have got to a 0.34. The CJ3 had a 0.6. I asked Mr. Hugestrop. He is the person most knowledgeable, the 30B6 witness, and one of the areas he's a 30B6 witness on is what the drag coefficient is of this particular bus, referred to the J4500. I asked him yesterday, could it be 0.6, 0.7, 0.8? Says could be, but I don't know. To this day, they have not measured the drag coefficient for the J4500. To this day, they cannot tell you what the drag coefficient is. In any event, they could have cut it in half from what the CJ3. Could have cut it in half. And I've already explained to you what Dr. Bredenthal said that would have done. Next. All right, this is what Dr. Bredenthal did with regards to comparing the J4500 with the CJ3. Next, please, Shane. Okay, so they bring Mr. Granite on the stand, and he is a mechanical engineer. They show him pictures from the wind tunnel test report, and they say, well, in your opinion, is the J4500 the same or different than the CJ3? Okay, they asked him that, and they showed him pictures, you know, they had it scripted out, and he goes, oh, it's different, it's clearly a different bus. And so what we did is we took 3 pictures of the J4500 and 3 pictures of the CJ3. We moved them a little bit, we changed it so it wasn't nice and bright white so you could tell which is which, and we made them look more alike and said, okay, you can tell which bus is better by looking at their shapes. Tell us what is the better bus here. Remember that when we did that? And this is what he said.
You can't tell from this picture what the radii is, right?
No, I would not rely on just looking at a photo as opposed to measurements.
Can you tell from this picture if this bus has better aerodynamic efficiency than that bus?
No, I would do measurements and I would do a wind tunnel test to evaluate the coefficient of drag if that's what your question is.
Bus number 1, can you tell if this bus has a better aerodynamic efficiency than bus number 3?
No, I would defer to the testing that was done.
See, he doesn't know that bus number 1 and number 3 here are the CJ3 and the J4500. So when we present pictures to him, as opposed to when they have it all scripted out, when we present pictures of him, he says, oh, I can't tell from the pictures. This is the only testimony that was presented to you that suggests that the J4500 has any sort of aerodynamic efficiency. The only witness, and again, Mr. Granite's not an aerodynamic engineer, doesn't have a bachelor's of science, a master's, or a doctorate in that subject. He's a mechanical engineer. Based on that, ladies and gentlemen, we submit that they could have made the J4500 aerodynamically better. It would have made a difference. Dr. Breenthal's told you exactly what it was. Instead of 10 out and 20 back, it would have been 3 out and 0 back. It would have made a difference in this case. Now let me move to the failure to warn. Shane, do I have a slide on this, your instruction?
Yes, but I think the number is off.
Okay, since I have no number, all right, here's our jury instruction. Even if it's the greatest product in the world, you have to have a warning. If without a warning, it makes the product dangerous, okay? Even if it's what would otherwise be considered a faultlessly made product, if you don't have a warning, that makes the product unreasonably dangerous. In this case, they did not have any warnings. You know, this is the warning section from the contract. You've seen this before. The only warning they gave to people buying this $400,000 bus, the only warning they gave is that somehow the air conditioning system can destroy the ozone in the upper atmosphere. Didn't tell them anything else about the bus. The important point here is there's no warning about an air blast. There's no warning about air displacement. They didn't provide any warning whatsoever. Dr. Kunitz was the warnings expert. He was a quickie, because, I mean, what do you need a warnings expert when there's no warning? But he said, in his opinion, he's the one from the National Bureau Standards from 75.
Now, don't tell me what Dr. Kunitz said in those materials. But tell me, do you have an opinion as to whether or not MCI provided an adequate warning with regards to that subject matter in this case?
I do have an opinion about that.
What is your opinion?
A, that it needed a warning, and they did not provide one.
No warning in this case. You don't even have to analyze whether it's adequate. You know, sometimes we get in these pharmaceutical cases, we're analyzing whether Lilly or somebody like that gave an adequate warning on the package insert. You know, that Lilly says there's 5 deaths, there's really 25, and so we say, oh, gee, that's not adequate. You know, sometimes adequacy of the warning is an issue. That's not an issue in this case. There's no warning. There's no warning whatsoever about the air displacement. And by the way, if anybody needs a break, oh, you do need it. See, if I hadn't asked you when to say anything. Your Honor, this is Dirty's break.
Okay.
All right, so they go this way and that way. First they say there's no air blast, and then they say, well, everybody knows about the air blast. You know, there's 2 inconsistent things in the case. All right, this is Mr. Dorr. He is their salesman down in L.A., at the service center in L.A. 20 years he's been selling the bus. He actually sold the bus in this case in September 2007. So I asked him if he knew about the air blast, and this is his answer.
Okay, what is your understanding, if you have an understanding, as to whether or not when a 2007 vintage J4500 is traveling 35 to 40 miles an hour, what is your understanding as to whether or not it causes air blasts or air displacements at the front of the bus?
I don't know.
Okay. You don't know one way or the other whether it would cause air blasts or air displacements?
No, I don't.
And I use the term air blasts or air displacements because, you know, sometimes they say, well, every vehicle does an air blast or air displacement. He didn't even know. He's been selling the bus for 20 years. That is evidence that a warning is needed. Okay, that's what Dr. Kuhn told you. Now, there's a jury instruction. In a warning case, you have to prove that the warning would have been acted upon. So the testimony is usually from the actor, the person who would have gotten the warning. In this case, it's Mr. Hubbard. So we asked Mr. Hubbard, what would you have done if you had gotten the warning?
Had you ever been trained as to a possible hazard of an air blast?
No.
In terms of your personal habits, if you're trained about something relative to safety, do you heed those training warnings?
Absolutely.
And you've never been told that a bus could create air displacement?
No, sir.
This is the testimony. He said he would have heeded the warning. That's why there should have been a warning. There wasn't a warning. He would have acted upon it. That's the warnings case. Now let's move to punitive damages real quick. A lot of the same evidence. This is the punitive damages instruction, the key part of the instruction. Okay, can I have it up? The conscious disregard portion.
I don't have that one in here. Do you have a number?
43.
43.
You it for
43 by 19.
Here we go.
Okay, 43. I'll get your jury instructions. This is what you have to prove to get punitive damages in the case. So we go back to that one. So this is what defendants are going to yell and scream, malice, malice, malice. Where's the malice, ladies and gentlemen? We don't see any malice here, okay? They haven't proved we acted with malice. So that's going to be their argument. We're kind of short-cutting it. But you get punitive damages when you have conscious disregard, which means you have knowledge of the probable harmful consequences of a wrongful act and willful and deliberate failure to avoid those consequences. Conscious disregard standard, that's what we're talking about here. We're not talking about malice. So when they start yelling and screaming about malice, they're setting up a straw man to knock down. So what is the evidence that conscious disregard, meaning that they knew about the safety devices, they didn't use them? Okay, what is on the right side blind spot, I've already played you Mr. Hugestrad's testimony. Again, he's the 30B6 witness. On the proximity sensors, I've already played you Mr. Hugestrad's testimony that he knew about the kits and they didn't use them. In addition, we proved that they had the industry magazine. Can I have that, Shane? And again, we have to show that they knew about the safety devices. That's why we're giving you this type of evidence. This is their ad. You can have the whole thing. It's an ad for J4500. And screen back the whole article. No. It's that article, the whole thing, so we can see the exhibit. This is exhibit 198. You want to look at the journal? Is this all we have, Shane? Okay, great. All right. So, leading industry publication that Mr. Hugestrad subscribes to, a number of MCI people do. The Bus Motor Coach News. This is the article announcing the BCI Falcon 45. It's called a 45 because it's a 45-foot bus. The important point is, on the next page, you have that pop-up sheet?
No.
Okay, on the next page, when you get the exhibit, read the second page of the article. They'll talk about that this bus, as a standard safety feature, has Eaton proximity sensors. As a standard safety feature, not an optional feature, comes standard on this bus. So what we're proving through this is that they knew their competitors were using the Eaton proximity sensor system. Yeah, and that's exhibit 198. I think I said that already. The safer alternative front, we've already talked about. Clearly they knew about it. They designed it in the wind tunnel test. The S1 guard. Now, Mr. Hugestrad says he never heard about it until this case started. We took the deposition of the parts guy. That's Pablo Ferraros. Can I have that, Shane? Okay. So this is the parts guy. So he saw it at the trade show. He doesn't remember if it was the aisles. He remembers some conversation about this product. This would be the S1 guard. The time period he worked for was 97 through 2000. 2000 would be 7 or 8 years before the coach, in this case, was made. So this shows that they had actual knowledge of the S1 guard prior to the coach being made in this case. Next one, Shane. Then he says, remember the flyer you saw with the S1 guard, the promotional flyer? He says he saw that. I think someone handed it to me, so he saw the flyer. He knew about the S1 guard. And remember Mr. Hugenstraat yesterday said that we had an obligation when we had an old product line, like the 92 product line, to look at the safety features and evaluate them. That's what he said. This guy knew about a new safety feature. But Mr. Hugenstraat apparently didn't come to his attention because he says he didn't know about it until 2017. Do I have another one, Shane?
That's all for Fiero.
Okay. So, in addition to Mr. Fiero, we asked Mr. Barron, again, he's the inventor of the S1 guard, hey, did you meet with MCI and offer them the S1 guards? So here is his testimony.
Do you believe that you have offered, that you met with representatives or subsidiaries of Motor Coach Industries and offered to sell the S1 guard to the manufacturer?
Not sale at that time. I believe I was going to do, because of safety, it's hard to sell. I wanted to let them, give them parts at no cost to get them on the buses so it would become industry mandated for the motor coach industry, because no one puts money out.
So he met with MCI, and he was going to give it to them at cost because he was trying to promote its usage in the industry. He wanted them to use it. But the important point here is he was going to give it to them for cost, so they didn't even want to try it out. Mr. Hugenstraat didn't even know about it. In this conversation, if you remember the testimony, took place sometime 97 through 2000, 8 years before the bus in this case was made. All right, and again, this is intended to prove knowledge on the part of the manufacturer of the S1 guard. Fourth way we're trying to show knowledge is they put it on over 50,000 buses since 1998. It's really hard to believe that MCI, the #1 bus seller in North America, didn't know about it. 50,000 other buses. All right, let's go to the verdict form. Is this in your packet, the verdict form? You do not have one.
I have it.
No? No? Okay. All right. Well, let's do a few seconds on this. When you get back there, and after you talk about the case, you criticize everyone's clothing, choice of ties, and you get to work. I know what happens back there, okay? This is the verdict form that you'll have to use in this case, all right? So can we kind of scroll up slowly soon? So read the jury. So the first issues are the liability issues. Is MCI liable for defective design? Was there a right side blind spot that made the coach unreasonably dangerous and a legal cause of Dr. Khiabani's death? Okay, so right side blind spot, I've already talked about that. That made the coach unreasonably dangerous, they gave an unreasonably dangerous instruction. And then the legal cause, again, this is the substantial factor, one I've already told you about. So you answer yes or no on this, you should answer yes. Lack of proximity, and you don't have to, we don't have to win all 5 of these, we just have to win one of the 5s. Okay. Are they liable for defective design? Proximity sensors, same kind of analysis. The rear wheel protective barrier, okay, it's really more than the S1 guard. It's could they have done it? And if you go back and you take a look at Mr. Pooch's testimony, he says, yeah, they had the expertise if they wanted to build their own little triangle thing. They didn't have to use an S1 guard. They didn't pay for it, even though it was free. So this is the rear wheel protective barrier, S1 guard. Is it defective design? And then the last one is the aerodynamics. The last one of the defects, and then we get to the warning questions. That's the shame, you might as well all the way through it. Okay, so if you answered yes, you have to do compensatory damages. We'll come back to those. Keep going. Okay, then are they liable for punitive damages? Yes or no? Again, this is the conscious disregard standard I just talked about. Did they know that these other products were out there that could have been used for this 1992 product line and disregard their use of those products? So yes, and then we ask you which one do you think they knew about and didn't use? Okay, so we got the right side blind spot. Come on, go up a little bit. We don't have to win all those either. And then, and I know you think that looks like a long verdict form, but in the Apple computer case that was tried about 2 years ago, Apple versus Samsung, they had a 78-page verdict form. So this is, it's longer than many cases, but it's not that long. All right, let's turn to damages. I'm going to be talking about the damages to Keon and also to the estate. Mr. Christiansen is going to be talking about the damages to Aria and to the estate of Dr. Okay, this is Keon Khiabani. That's his birth certificate. It's in evidence. Born at Sunrise Hospital. That's Sunrise Hospital, just to show you. That's Keon. At the time of the accident, he was 13 years old. He's 14 years old now. As Aria told you, he was going to Clark High School. Now he's moved up to Montreal, and he's living in the basement of his uncle and aunt's house. And it's a big case. The community's watching this case. MCI is watching this case. A lot of interest in this case, and a couple reasons. One, the tragic, needless, and senseless loss to the Khiabani family. That's one reason they're watching it. And two, it's an important issue. Safety on vehicles that weigh 40 100,000 pounds that travel through our city seats. That is a very important issue. That's why this case is getting so much attention. Now, during opening statement, Mr. Terry suggested to you that the defendants were going to offer a different remedy other than money for compensatory damages. Okay? I know you don't remember what he said at that time, so I want to play it for you.
We recognize that these young men have suffered an injury. We just don't know that money is the way to resolve it. Millions and millions of dollars is the way to resolve it. And we will explain that to you after you have had a chance to review the evidence.
Okay, we found out when Dr. Smith, their only damages expert, Dr. Smith, the guy from Chicago, he came to the stand, we found out what they thought the alternative to money was. This is what Dr. Smith said. And again, this was a planned and scripted question. You know, they knew what the answer was going to be before he gave it, but here's what he said.
And to speculate as to how much he'd be given to his children 15, 20 years from now, in your opinion, would that be highly speculative?
I think so, and you don't want to give an 18-year-old $500,000 anyway. You'd rather give him a bottle of whiskey, frankly.
A bottle of whiskey. This is what Mr. Terry and Dr. Smith want to give to Khiabani. A bottle of Jack, okay? That's what he told you. You'd rather give them a bottle of whiskey. That's their position in this case. Well, that was crass. That was uncaring. You know, they know that whiskey is not on the verdict form. That's not an option. You don't have a blank you can fill in and say, you know, bottle of Jack or 2 bottles of Jack. They know we're talking about money damages. And so why would their expert make such an outrageous suggestion? Why would he do that? Well, it wasn't because they really think that you're going to give out bottles of Jack. That is not why he did that. The reason they did that is they are trying to get a subliminal suggestion to you that these boys should not get the money they deserve because they're going to blow it. They're going to take the money and go buy Jack Daniels and go out and party, you know, so you shouldn't give them what they're entitled to because they're going to waste the money. That's why they did that, okay? And so Mr. Christensen and I, we saw this coming, and so that's why we had all the evidence. I don't know if you remember, but we had all the evidence about the guardianship. This is what Katie wanted. And we presented the testimony from the guardians, and you know the forms were signed in the Canadian courts, and we have guardians. That's why we presented all that testimony. You know, I'm sure some of you wondered, what the heck does this have to do with anything? The reason it has to do with something is we wanted to assure you that the guardians of these children, can I have their picture, Shane? The guardians of, do we have MCs in the box? Okay. You know, Shane and I were up late. We're not perfect. So we had MC's testimony. She was the one that was the school professor from Montreal. And then we had Babak Barron's testimony. He's Katie's brother. He's the one who's a judge. So those are the people who are the guardians of these children. No one is going to go on a wild drinking binge and drink bottles of Jack. That is not going to happen. So let's go back to that. Can I have the compensatory section, please? Okay. This is the form that you're going to be given. This is Keon. We have 1, 2, 3 types of damages. I'm going to describe them in the first two I'm going to describe in a lot of detail. The other one, loss of probable support, Mr. Christiansen is going to cover because the same kind of analysis relates to ARIA as it does to Keon. So I'm going to cover the first two. Keon is entitled to past grief and sorrow, loss of companionship, and the companionship in this case would be he lost his father. He lost his father. Society, being around his father, comfort that he would have gotten from his father. From the past, that's from today, back to the day of the accident, and then the future. The future, so those are the two elements I want to start talking about. Now, You've been given an instruction that you should consider the life expectancy. If you have an heir and someone who dies, you take the shorter, you take the shorter life expectancy. So in this case, the life expectancy table, which is a jury instruction 38, it says that Dr. Khiabani would have lived another, 38 please, Chief. Quickly, I don't want it. All right, it says that Dr. Khiabani would have lived another 31 years. So this is the time period that Keon has been deprived of his father, 31 years. You know, you have other evidence besides the life expectancy table. Can I have my next, please? If you recall the testimony, Dr. Khiabani's parents were visiting at the time of the accident. Let's hold that, Shane. Hold that, please. And they're still alive. So in addition to the life expectancy table, which is an estimate, that's a general estimate based on the whole public, we have the fact that his parents are still alive. So the issue is, what should you award for, and that's the picture of him with the parents. Looks like a news department. But in any event, they're still alive. They were the ones that were at the house, and then we wouldn't, you remember the story that I already told you, he didn't come home. So Keon was with them and he couldn't speak Farsi. But in any event, his parents are still alive. So in addition to the life insurance table, we've shown you, or excuse me, the life expectancy table, we've shown that, and it's 31-year life expectancy. Now, there are no mathematical formulas here. Okay, you've been given an instruction that there's not a mathematical formula. You know, some jurors, in fact, some of you came into this proceeding and said, gee, I wish we had a mathematical formula. There is not a mathematical formula. You have to look at what type of family bond this particular family had and evaluate if in the future Dr. Khiabani would provide, he'd be there for the son. That's really what you're looking at in this case. And so, start with a little bit about Keon, and then the other evidence from Arya about the family bond. Go ahead, Shane.
So my brother has a strong form of ADHD, and so he struggles in learning environments and in the classroom, and just in general, like there's a attention deficit hyperactive disorder.
ADHD, that's a serious condition. There's a lot of children out there that have worse conditions, but that's a serious condition. Let's have the next one.
What experiences that you got to have will Keon miss with your father?
My dad was always, I mean, you could see in the photos, he was always there for us. Like we'd wrestle on the couch, or like we'd make a band, right? My brother would play drums, I'd play bass, and my dad would play guitar, and we'd play rock songs and so on. And he was always very hands-on in that sense, and at soccer games or music performances. But then when we got older, even more, which was amazing, right? Because usually kids distance themselves from their parents. I got even closer. And my dad was there to not only help me with academics, but just in terms of life advice. Like what happens when you have a problem with a friend, right? And you want to fix that problem. Like the best way to learn is from your dad or a guy who's been through that. Or if you want to ask a girl out on a date, how do you do that? How do you go about doing that? And he was the master at that. And so all these sort of lessons that I got to learn as I got older, my brother unfortunately won't get, or at least not the same from his own father.
Okay. What do you do? Strong family bond in this case, and let me give you an example of a family bond that's not strong. You all know who this guy is? Steve Jobs. This is copying his autobiography, which, by the way, is an excellent read. But in any event, Steve Jobs died recently. He was the guy who founded Apple Computer, came out with the Apple iPhone, Mac, all this stuff he gave us. Okay? He had, when his daughter was born, he disputed paternity. He fought it. Court ordered him to pay whatever they make you pay in California. He didn't go to the daughter's birthday parties, didn't buy her birthday gifts, didn't see her on Christmas. So he had a weak family bond. So if you, as a jury, were evaluating his family bond, that would be a weak family bond that you should give less compensation for. You should give more compensation for a strong family bond. So what we're going to suggest to you is that you take the life expectancy of Dr. Khiabani, the 31 years he would have been there for Keon, and whatever you deem to be an appropriate monetary award per year, that should be the monetary award for loss of the father. And the way that works is if you said it was $500,000 a year for 31 years, you do the math, it's $15 million. If it's $250,000 a year, you do the math, it's, you can do anything you want to do. But the first thing you have to do is evaluate the strength of the family bond, and then the next thing you have to do is determine appropriate compensation level for the 31-year time period. Now, Keon testified by video, okay? I didn't want to bring him here. He's a 14-year-old boy. I just didn't want to bring him here. I could have brought him here. We brought his brother. But we had him testify by video, and I think you can understand why that's appropriate. So what we did is we had Aria describe what the loss would be to Keon. Can I have that clip, please, Shane?
What experiences did you got to have with Keon miss with your father?
My dad was always, I mean, you could see in the photos, he was always there for us. Like, we'd wrestle on the couch, or like we'd make a band, right? My brother would play drums, I'd play bass, and my dad would play guitar, and we'd play rock songs and so on. And he was always very hands-on in that sense, at soccer games or music performances. But then when we got older, even more, which was amazing, right? Because usually kids distance themselves from their parents. I got even closer. And my dad was there to not only help me with academics, but just in terms of life advice. Like, what happens when you have a problem with a friend, right? And you want to fix that problem. Like, the best way to learn is from your dad, or a guy who's been through that. Or if you want to ask a girl out on a date, how do you do that? How do you go about doing that? And he was the master at that. And so all these sort of lessons that I got to learn as I got older, my brother unfortunately won't get, or at least not the same from his own father.
That's what Aria told you. It's a pretty commonplace experience. Instead of this is Keon's fate. That's his experience with his father from this time forward. No father to wrestle with him on the couch. No father to go to the soccer games. No father to teach Keon music. No father to help him with his schoolwork. No father to give him life advice. No father to teach him about dating. No father to attend the key events of his life. And no father to give him support in his moments of need. That's Keon's fate. And that's the loss that needs to be compensated in this case. And like I keep saying, there's no formula. You take a look at jury instruction 40, they'll tell you that there's no mathematical formula, no method of calculation. It's up to you. No limit on it. I mean, The third item I want to talk about is the pain and suffering of Dr. Khiabani. And again, I move from Keon now to the estate claim. The doctor is entitled to recover his estate in any way for the pain and suffering and the funeral expenses and the medical expenses. So the big issue is, did he lose consciousness immediately, or did he have some pain? Obviously there was some pain because he hits the side of the bus and then he falls down, breaks the ribs, and is run over. Okay, it's not the situation where he was run over first and then he hits the side of the bus. And this is Dr. Gavin explaining that.
In your opinion, would the contact with the asphalt before the bus runs over his head have caused Dr. Khiabani to immediately lose consciousness?
It depends on the time between when he's struck and hits that. I don't know how many seconds or milliseconds when he's struck by the bus on the under portion versus him hitting the ground.
And when he hits the ground, at least prior to the tires hitting his head, would he experience pain?
I imagine that would be painful, yes.
And when the bus ran over his head, would that have been painful?
Yes.
And I'm not suggesting this category is entitled to tens of millions of dollars. They're going to tell you it's zero. It should be zero because there's no pain and suffering, no contract. That's what they're going to tell you. I'm not suggesting that this is the big ticket item on the damages form. But I am suggesting that he got run over by a bus. That would be painful. He hit the side of the bus. He broke his ribs. That would be painful. That is entitled to some compensation. I want to talk a little bit about Dr. Khiabani. Next slide, please. Oh, excuse me, before I do this, this is Samantha Kolch. This is one of the witnesses, the key witness on the pain and suffering. She was the one that testified left, right, she saw for 2 seconds, and that's after the accident, and that's a factor to determine pain and suffering. So this is what she actually said.
I'd like to talk to you about when you first saw Dr. Khiabani after the accident. And you told Mr. Christiansen that he moved first one shoulder and then the other shoulder maybe twice for each shoulder. Is that fair?
Yes.
And when you were initially recalling that, you thought he had maybe moved for a split second. Do you remember saying that?
Yes.
But your best recollection now is it may have lasted about 2 seconds.
Yes.
1,001, 1,002.
Yes.
1,001, 1,002, he's still moving his shoulders after the accident. All right, let's talk about Dr. Khiabani just for a second. What an amazing story. Born in Iran, leaves Iran, escapes at the time of the revolution through the mountains by himself when he's 17 years old, and he goes to Pakistan, and then he goes from Pakistan to Canada. Starts working in a McDonald's. These are pictures of those McDonald's hats. You know, I have a tough part on this one. It's just so incredible to me that a man could save McDonald's hats to show them to his sons as evidence of what hard work can do for him. Hard work made this man a doctor. So he was the professor of hand surgery at UNLV, chief of hand surgery at UMC, he was a plastic surgeon, but he didn't do breast implants, he didn't do facelifts, he didn't do things like that. He operated on people with deformities. And Dr. Barron told you a little bit about the story called Hannah's hands. Hannah was the one, she was a 5-year-old, and the shotgun blast blew off both of her hands. And Dr. Khiabani restored those hands to her. When Hannah came to his funeral, remember Dr. Barron told you about that? Even after his death, he kept providing for his community. They stripped his skin off and they gave it to bird victims. They took out his corneas and restored someone's sight. So that is Dr. Khiabani. The other damages element is pretty simple. We have it. It's the medical and funeral specials. I don't think they're going to spend a lot of time talking about it, so I'll just give you the number. It's about $46,000. There's a spot on the compensatory damages for medical and funeral specials. You can just put the $46,000. If someone wants to make a note about that, it'll probably save you some time. And that concludes my closing statement. Thank you very much for your attention. I appreciate the attention you've shown. All right, this is rebuttal. This is what's called rebuttal. So what that means is when they made a point, I get to rebut it. I don't get to make up entirely new points. I'm limited by the points they made, and then I give our response. It's like that show, Point, Counterpoint. I saw that back in the day. In any event, first, and because it's rebuttal, we jump around a lot. There's not a lot of flow here. So I just take their point, and then I rebut, okay? So the first point I want to talk about is Mr. Barger's point on what you have to prove to get punitive damages. Shane, can I have the conscious disregard instruction? He told you that we have to prove that MCI did it, quote, on purpose. unquote. We don't have to prove MCI did it on purpose. You know, in a battery case where someone hits someone, they have to prove that that was done on purpose. In this case, all we have to prove is conscious disregard. Knowledge of the probable harmful consequences and a willful and deliberate failure to avoid these consequences. Failure to avoid. What did they do in this case? They sold a 1982 product line and they didn't update it regularly. They didn't update it. You've seen the testimony already. There is no requirement that we prove that they intentionally did it, that they purposefully did it. We just have to prove conscious disregard. Next rebuttal point. Mr. Barger started with a lot of witness testimony, and I think the intent there was to show to you that if you cherry pick, and that's what we call it, that's a term of art, if you cherry pick it, you take a little bit from this witness and a little bit from that witness and a little bit from this witness, you can make it sound like the witnesses are all inconsistent. Okay, and you can especially do that if you don't show all the key testimony about a witness. And let me give the example. The first thing he did is he showed you questions and answers about Mrs. Bradley's testimony when she said in her deposition, didn't say this at trial, she said in her deposition, her first impression, when she was trying to make sense of what was going on, her first impression was there was a swerve to the left. Okay, do you remember how he showed you that testimony? Okay, what he didn't show you is the testimony about what Miss Bradley testified she thought happened. All right, let's move to federal standards. They argument that there's no federal law that makes them have a proximity sensor. That's true. That's true. So what they're really arguing to you is we are not going to make a safe product with proximity sensors until the federal government makes us do it. That's what they're saying to you. The fact that there's no federal standard one way or the other. They're not precluded from using proximity sensors. The other competing bus, the BCI, did in fact use proximity sensors. That's Exhibit 198, we already talked about it. Jumping forward to a different subject. He said that the ozone language we had was on a, quote, sales slip, unquote. That was not on a sales slip. That was on a 20-page purchase agreement for the sale of the bus. And then he said to you that, well, if you look at the manual, there's warnings in the manual. Take a look at the manual, ladies and gentlemen. It's Exhibit 135. It's about 200 pages long. It goes on and on about the bus. Not one single warning in that manual. And the point is, there's no warning in this case. Next, he put up jury instruction 26. Can I have that, Shane? And Eric, can you give me the Recoba testimony so I can read it in if I have to?
I have it.
Oh, you do have the Recoba. All right. Back to Mr. Recoba. Again, this is Mrs. Bradley. They've cherry-picked, and so Mrs. Bradley supposedly said it was her impression that the bike swerved to the left. This is what Mr. Recoba testified about what the true testimony was.
She later on said in that deposition that her first impression was wrong, right?
I don't recall that portion of the deposition.
You don't recall her saying later on in the deposition that her first impression was wrong?
No, can you show me that?
Different, is that fair?
Again, if you show me that text, I don't remember that line of comments by her about being different or wrong.
Actually, she gave a potential cause for the wobble in her deposition, did she not?
She said it was possible.
Possible that it was a...
Oh, that it was an air blast.
Okay, so he cherry-picked a portion of Mrs. Bradley's testimony where she said her impression was that it was a left swerve. But what she really said, when you look at the whole testimony, she really said that it was possible that it was an air blast. And I don't want to go through all the witnesses, we don't have time. Next slide, this is the consumer expectations test. I talked about it, and Mr. Barger talked about it. I just want to emphasize one thing again. Can I have Jay, jury instruction 26, please? All right. You judge whether or not the product is unreasonably dangerous by the ordinary user. Okay, in this case, the ordinary user is the bus driver. That's why I emphasize to you all of the bus driver testimony about proximity sensors. Mr. Hubbard wants them, Witherell wants them, Sherlock wants them. Everybody that was a bus driver that testified said the bus should have had proximity sensors. Everyone that was a bus driver that testified, Mr. Ellis, said that the bus should have had an S1 guard. Everyone that was a bus driver that testified said that it had a right side blind spot, okay? That is whose testimony is relevant. The ordinary user, the bus driver, not an expert witness sitting on the stand, not an attorney making up an argument, but the bus driver's testimony. That's the ordinary user. So what was missing in the trial? Can I have my next slides, Shane? I don't know, you don't see these so much because we have this Amber Alert now, but back in the day, you used to see these missing mailboxes all the time. What was missing? They did not present one single bus driver that testified there's not a blind spot. No testimony whatsoever. I already referenced the 3 people that we called. What's the next one, Shane? Didn't present one single bus driver witness. This is the ordinary user. The bus driver is the ordinary user. No bus driver testimony that proximity sensors are not needed. The only witness they presented on this was Dr. Krause. And what did he tell you? He told you they were great for his wife to avoid running over bikes in the garage, okay? That is the only witness they put on with regards to proximity sensors. No bus driver testimony. Next one, Shane. No bus driver testimony that an S1 guard's not needed. I talked about Mr. Ellis's testimony. Again, he's the bus driver up for New Flyer. He testified that S1 guards is a good safety measure. Mr. Barron testified to it. We presented the victim. But they presented no testimony of the ordinary user with regards to S1 guards. Next one, Shane. No testimony from a bus driver that an air blast warning was not needed. They didn't present that, okay? We presented that. Can I have Ms. Witherell's testimony? And you told me that you don't know one way or the other whether or not all buses produce the same type of air blast, right?
Right, sir, I would assume they all do.
And if one produces twice the air blast of another bus, do you think that manufacturer should be warned?
Yes, sir.
Why is that?
Just more knowledge that you have, and for the public's knowledge.
This is the only bus driver testimony in the case about whether a warning is needed. And she says if there's a differential, in other words, the Mercedes Cetra 500 has a 0.33 drag coefficient. This bus, according to Dr. Friedenthal, had a 0.6, twice as much for this bus, the J4500. She said there should be a warning. This is the testimony of the user. Okay, let's switch gears a little bit. I told you they tried a finger point. I told you that. What did they do? They showed you the speaker on the doctor's bike, okay? Why did they show you the speaker on the doctor's bike? Because they wanted to imply to you that maybe the doctor was listening to loud music and somehow or another that was a factor in the accident. So that's wrong for 2 reasons. First of all, the gardener testified he didn't hear any music. That was the testimony in the case. That was the only testimony in the case about whether there was music. He said no music. But the second reason it's wrong is they're finger pointing. They're pointing at the doctor. They're implying that merely because there was a speaker on the bike, and this is pretty desperate, a speaker on the bike there's no evidence was using, they're implying that the doctor was negligent. That's finger pointing. That's forbidden by jury instruction number 34. All right. They told you that according to, they told you that Mr. Hugestrat and MCI were not aware of all these problems, that they weren't aware about the right side blind spots, that they weren't aware about the aerodynamic problem, that they weren't aware about the high dashboard. Well, this is what Mr. Sherlock testified that he personally told MCI. And I have my Sherlock clip, Shane.
What did you
tell MCI about MCI buses?
Well, we've had a rather extensive conversation where we got together and looked through the driver's workstation and the issues there. Everything from that dashboard that comes back so you get better sight lines, better ergonomics, through going out and specifically looking at the pillar structure and the curvature and what that would do to the airflow, and everything from driver vision through the interior air quality and disturbance to people proximate to the bus, near the bus as it goes by.
And when you talked to MCI, did you actually have a J4500 available?
Yeah, we were standing right in front of one.
And did you explain the dash problem to them?
Yes.
Did you discuss aerodynamics?
On the dash, yes.
So they told you that they didn't know about all these problems, yet the safety analyst for the ATU, 200,000 bus driver union, told them about this, told them about it. Now, they referred to Mr. Granite's testing. Let's, and that was he rode bikes back and forth behind buses back and forth behind stationary bikes with a 200-pound dummy. There were 3 problems with that. Dr. Greenthal criticized it. I don't want to play that, Shane, that's too long. But what he told you is that, in his opinion, that was a flawed test because of the inertia in the test object. In other words, the bike weighs 200 pounds. So there were 3 problems with these tests. 1, they didn't take any wind measurements. They did not measure wind, okay? When we had Mr. Granite on the stand, we showed him this device and we said, all right, what wind did you measure when you kept running those buses back and forth? They didn't measure the wind. Remember, Dr. Greenthal estimated it was 40 miles an hour? How easy would it have been to set up one of those, okay? They didn't want to know the wind. What they said they were doing is they were measuring force. So what they did is they hooked up a measuring gauge onto the 200-pound test dummy, and they measured force. Okay, Easter Island, these are one of the big statues that are there. This is an island in the middle of the Pacific. Hurricanes go by it, they don't blow over the statue. And the concept that we're trying to explain to you here is that when you have a big, heavy object, and you hook up a force gauge to it, and the bus goes past, the force is just too quick for the object to register on. That's what Dr. Greenthal was trying to explain to you. Inertia and speed. So this is the test they ran. They ran this kind of inertia test. They didn't run the wind measurement test. And the 3rd flaw, we've already gone through it. The day they did the testing down there on the 7th and the 8th of October last year, we got 10, 12, 13 mile an hour winds. And so you're trying to measure air force coming from air disturbance coming from the front of the bus. How can you do that when the wind's going this way, going that way, going this way? So those are the 3 flaws. Now, Mr. Barger argued to you that, the J4500 has similarities to the safer alternative design, and that we tried to streamline it when we designed the J4500. Remember him saying that to you? Well, here's what the designer said.
He objected to that form question. It's not what I said at all.
You said, quote,
Overruled.
all right, next, here's what the actual designers said with regards to what they did when they're trying to design the J4500. Can I have Mr. Lamont, please? So as far as you know, when the J4500 was designed, no one looked at aerodynamics as a safety factor, as far as you know?
Not to my knowledge.
Next one, Shane.
Did MCI make any effort in designing the J4500 to reduce the aerodynamic drag by modifying the shape of the front of the coach?
I have no knowledge of that.
This guy's on the design team. He has no knowledge of it. Next one, Shane.
So, in addition to making the right-hand corners more rounded, you can also make the roof slope more rounded. Is that correct? In theory.
In theory, yeah.
Was any consideration given when you designed the 4500 to designing it with a larger radii for the roof slope?
Not that I'm aware of.
This is the actual designer. They didn't do anything when they did this bus, J4500. Didn't do anything to make it more aerodynamically efficient. And that's my rebuttal. Thank you again for your attention, ladies and gentlemen.